All right, and we're back. So this is my second time recording this one because apparently I forgot to click the record button last video. That was great. So I'm going to go very fast through this one. Hopefully the dog, hey, why don't you get off the bed if you're going to be chewing on yourself and making everything move. Dogs, gotta love them. All right, but at least this time I'll be able to get through the video without someone coming into the room, which will be nice. All right, so this one we're dealing with defenses to criminal culpability. Let's back up. All right, so first thing we should talk about are defenses. They're either complete, like full, complete defense, which is basically a person who's being who's the defendant will be acquitted. That's complete defense. A partial defense is one in which they won't be found not guilty, but they'll be found guilty of lesser offenses. So in the last video, I mentioned the fact that most crimes will include lesser offenses. So if some aspect of the most serious charge isn't established, that you have that option for jurors to find someone guilty of a lesser charge. So anytime we're talking about defense, what we're talking about is, so if you're going to convict somebody, we're talking about that reasonable doubt standard. The person must be found guilty beyond a reasonable doubt. So what a defense needs to do is there's a few different ways they can go about it. One is basically introducing doubt to the jurors, whether it's poking holes in the prosecution's story, the evidence that they put forward, what they're trying to establish, the facts that they're trying to establish, introduce more doubt to poke holes in it. And that way you can have a partial or a complete defense. Or the other one would be to go with an affirmative defense. So an affirmative defense is any time that the defense is putting forward a type of defense which requires the defendant to prove certain facts beyond the preponderance of the evidence, based on the preponderance of the evidence. That's the phrase. So if you stop and think about it, beyond a reasonable doubt, people will draw different percentages for that. I typically say 95%, maybe 95% certain. Preponderance of the evidence is more like more than likely. So much lower threshold. One of the ways you can kind of see that we are as a society more bent towards, keeping the innocent free and allowing for the error of the guilty to go free than we are for convicting the guilty and sometimes convicting the innocent, even though we still convict some of the innocent. So with that, talk about that. On that first slide, I've got a few cases listed. Those are at the federal level, so that they're important, but they won't necessarily be in your textbook. So Sandstrom versus Montana. Yeah, that one's related to intent in terms of one can, the ordinary consequences of one's actions, voluntary actions. Basically, that's what someone intends. If you're driving down the street, you see a person on the sidewalk and you just kind of move your car over, it's like, yeah, you can, that person intended to run over that person, right? That person intended to harm that person. That person intended to harm that person to a serious or even deadly degree. I was like, that's what you're talking about, that, the ordinary consequences of one's actions. So this topic, whenever we talk about it in class, I tend to talk, before we really get heavily in the lesson, I have a discussion with students about responsibility, when one is responsible for actions, when they're not. Kind of see where that discussion goes, because it's going to deal directly with this. A lot of these defenses, a lot of the topics at hand, and then some of the ones that we'll talk about later. Because this is where you start to negate some of the responsibility for one's actions and what situations are they warranted. Francis and Franklin, basically that one has to do with this. In fact, the prosecution must prove all the elements of the crime they're seeking, the charge that they're seeking, beyond a reasonable doubt. So any one of those elements isn't proved beyond a reasonable doubt, you cannot find that person guilty of that crime. What that means is typically what ends up happening with is intent, because it's the hardest to prove. And that's, like I said, why they include lesser offenses. Because if you don't meet with the most serious, I bet if you drop down, one level of intent, meaning one stair step down in that level of seriousness, that jury might be able to establish that. Martin versus Ohio. Affirmative defenses must be proven based by a defendant based on the preponderance of evidence. So that's basically, again, what that one deals with is the fact that since the defense is putting forward an affirmative defense, they have to be the ones to prove it. It's not a shifting of the burden of proof in terms of the criminal action, but you're introducing more evidence as a way to negate it that needs to be proven as well. And that's why I put in there an insanity defense, affirmative defense, or negation of intent. That one was the topic of the discussion for this week, and I'm kind of curious to see what people say, and then I'll kind of weigh in soon. I'm a little bit behind on that. I'll have that done probably by tomorrow, and that'll be the only time I run and take the full week that I said, from the time something's due to the time that I grade it, just because this last week was so crazy. Okay. So types of defenses. The first one I have listed here is ignorance or mistake. Basically, are you aware that the law exists? And then mistakes concerning collateral elements. So there was some other mistake made that related in that type of crime. So it wasn't on purpose. It's like, yeah, maybe to intent to some degree, but it doesn't excuse you from anything. In fact, at the very end of the slides, I have in there the Oklahoma statutes where it literally states that ignorance does not excuse one from the punishments associated with the crime. Basically, what you're talking about there is maybe a partial defense at best. Duress and necessity. So duress is caused by people. Necessity is caused by nature. Is a good way to separate out those two things, but they're talking about the same thing. You're forced into committing some type of act that's criminal. So duress would be, someone's kidnapped your favorite dog. What are you doing? Be a good dog. Yeah, someone's kidnapped your favorite dog and is holding it ransom. And what it is they want you to go and murder somebody, and they'll give you your dog back. And some people would go and do that. Looking at you, dog. She's causing trouble. But that would be duress. Some person has caused that. So necessity would be more along the lines of you went for a hike out in more rural area. You got lost. You've been stuck out there for 3 days. You happen across a cabin. Looks like no one's home. You break in and you steal the food in it and eat it. And you got the shelter you need, and you got the food you need to keep living. That kind of thing. That's circumstances. That's nature. Infancy is always a fun discussion in class because we start talking about ways society's been changing related to this one. This is one you want to keep a close eye on. Basically what it is they talk about the inability for children to form criminal intent, that at a certain age they lack the ability to understand the consequences of their actions. Here in this state, if you're under the age of 7, you won't be charged with the crime at all. And then between the ages of 7 and 14, there's some discussion to be had about it, essentially, to identify whether or not you can appreciate the wrongfulness of your actions. The reason why it's such an interesting thing is because, the way that you look at, alcohol, tobacco, and firearms, some of my 3 favorite things. The way that those have been moving in the last few years is the age at which someone could have the access to those has been increasing. So in some ways that basically the younger generations are being treated more and more as they are, incapable of handling such materials. At the same time, in some places, they're looking to move like voting age down to 16. So it's like you have different things going on in society in different directions, and it's something you need to keep an eye on because it's not moving in a common direction. I wouldn't say it's moving in a good direction at all. In fact, that some ages for certain things being moved up because at the age of 18, you're an adult. You should be treated like one and have full rights for everything. But I guess the infantilization of the next generation shall continue. Insanity. So there are a few different tests for this. Oklahoma State tends to fall under. Make sure this is recording. It's not. Yes, it's recording. I was gonna flip out there because if it wasn't recording me again, I was gonna use some. But okay, so there are a number of different number of different types. I believe Oklahoma falls more closely along substantial capacity. So when you're dealing with substantial capacity, it's the person can't be held accountable for their actions, that they have the inability to appreciate the fact is wrong or conform to the law, basically. But realize whenever we talk about insanity, you're talking about a legal term, not a medical term. So that's the first thing to be aware of. M. Naughton rule. Message. Okay. So basically, what you're talking about there is, does the person know that the act that they had taken was wrong? That's the M. Naughton rule. Irresistible impulse is basically you're unable to control their actions, one's actions, even though you know it was wrong. Durham rule is that the action was the product of the mental defect or disease. So it's because of, they have to establish that. Substantial capacity we were talking about. Guilty but mentally ill is sort of that in-between stage where you've established the fact that there's some mental illness there that's contributing to it, maybe, at least that one is mentally ill. You're still guilty of the actions, but that means you'll more likely receive treatment whenever you are incarcerated. May not be considered fully insane, but that there is some mental illness there that needs to be addressed. I have it here, abolition of insanity defense. So some places have started to abolish the insanity defense, but that's not, not many by most accounts. Most will have that. Diminished capacity, not insane, but you don't have the mental faculties to meet intent. Basically, what we're talking about is mental, I should say mental retardation, that, one doesn't have the mental faculties that the average person would. And the Oklahoma has a statute related to that too, or at least part of the defense statute. Automatism, anytime we're dealing with that, you're talking about things that not voluntary actions. So here it mentions unconscious and unconscious state. Epilepsy is a good example because let's say a person doesn't know they're epileptic, they're driving, they have a seizure, then they jump that curb and run that person over. It's like that's not something that had any control over. And you're seeing more and more of that stuff come out in the last couple of decades. High profile cases. So and so was taking sleeping pills. They were asleep, got up, drove their car, went for a run or whatever, and some type of criminal activity took place. Yeah, that's not something they fully have the ability to control, so it's not voluntary. Entrapment. There are two tests for entrapment: the objective and subjective tests. So objective, it focuses on the government actions, the government agents' actions, basically were they so much so that they instilled the idea for the person to commit said crime. The case that dealt with that is back when, I want to say, I can't remember the date for it. But essentially what it was is whenever pornography was sent through mail, not through online stuff, and they had a person who's convicted of crimes against children. And so what the police did is they started sending him in the mail advertisements for child pornography. It's pornography, including child pornography, for about 18 months. So after a year and a half, person finally ordered one. And at that point in time, they picked him up for the crime. Now realize that it was a year and a half. So that's the conduct there was such that that they were able to say that person would not have done that had it not been for the repeated efforts of law enforcement to cause said act. The subjective test is one that focuses on the disposition of the person who's charged. So what that means is if you have a criminal history for such actions, you can't use entrapment as a defense. Basically what that means is like, let's say a prostitute, been convicted multiple times. Government agent goes up and basically acts like a John to go pick her up. She agrees, and at that point in time, it's like there is no entrapment there because of that person's history with committing that crime. Oklahoma, I believe, uses the subjective test. Some states use the objective test. Some states use a mixture of the two. outrageous government conduct. So if there's particularly outrageous government conduct, they won't prosecute the crimes. So that's some major violations there of people's rights, that kind of thing. Defense of persons and property. Here it says requires the unlawful threat of immediate violence, serious bodily injury by an aggressor, reasonable level of force used depending on the circumstances. So basically, this is a conversation about force, and there's a spectrum to be aware of in terms of one's ability to use it. So to kind of give you here in the States, you have like stand your ground, you have castle doctrine, and then on the other side of the spectrum, you have duty to retreat. So stand your ground means you don't have to flee. You can stand there, you can fight there even outside of your own home if someone puts you into some type of dangerous situation, up into including the use of lethal force if it's called for in the situation. Same thing in your home. Duty to retreat, that was like Illinois where I grew up whenever I was a kid. It was a duty to retreat state. I don't know if it still is. I assume probably is. Basically, what that means, if someone kicks in your front door, it's your duty to run. You have to make that decision to leave your own home while that person takes whatever it is that they're there for. It is up to you to try that first, and if you cannot at that point in time, that's when you can engage in self-defense. The situation is like, we're not really talking about defense of property. You're talking about the threat of death or serious injury, maybe while you're on your property, that kind of thing. Basically, in terms of where we're at as a society, all over the map, people are moving more and more away from more and more towards that duty to retreat, where that person, the life of the offender is more valuable than the danger presented to the person who's being victimized, which is not a good situation. Here in this state, we're more towards the more protected side, in that a person can defend themselves. I have the statute in here in the PowerPoint later. You can look at it, hopefully you have already. Basically, the way to look at those situations is, who do you want to make to be the determining factor in how much victimization takes place? Do you want the person who's already decided to victimize someone in some way to be the one who determines, how much, in what forms of victimization, who's targeted? Or do you want the person who's being victimized to be the one who determines whether or not the victimization will take place? Another way to put it is, let's say you live in a duty to retreat location. Someone kicks in your front door. You have to figure out whether they're there for your TV, your safe or whatever, you or your children. It's like, that's not going to be something that's immediately apparent. You're just going to have someone in your door who's coming at you. So if they continue to take chase and you're not able to get away, then maybe they're there for you. Are you going to be in a situation you can defend yourself? Probably not. So it's like, who do you want controlling that situation? I'd rather not have the person who's chosen to take criminal action be the person controlling the situation. I'd rather it be the person who's being victimized who is otherwise lawful. The fleeing felon rule here, that's something just to be familiar with. That refers to Tennessee versus Garner. You've probably heard that case before. If not, you should be familiar with it just because you're associated with criminal justice in some way. Basically, you're talking about in the 70s and before, if a person had committed a felony and was refusing to be arrested, fleeing the scene, an officer could use deadly force to stop them. Following that case, it was found to be disproportionate with the situation unless there was that risk, that threat of imminent death or serious injury. And it was both good and bad. I mean, you don't want to have that kind of disproportionate power, but also at the same time, in terms of those who flee and try to basically escape arrest, it's like you've massively increased that. So it's like you get a little bit of good and some bad with it too. I should say a lot of good and some bad with it too. All I need to say about that. Intoxication, voluntary versus involuntary, two wildly different things. Voluntary, again, you're talking about the reasonable outcome of someone's actions. If you're going to be drinking, you got drunk, you went and drove, yeah, you're going to be held responsible for that because that was an ordinary consequence of your action. If you're drinking, you chose to drink, you're not going to be making the best decisions. And guess what? You made some bad ones that you're responsible for. It's involuntary, like you were drugged, different entirely, because at that point in time, you had no choice in that matter. Consent and condemnation, not a defense. In some places, we start talking about euthanasia, maybe assisted suicide. You'll have an option to talk about that next week. It's not a defense. The major thing to take from that is just, anytime you see a crime that's charged, one who makes the determination as to whether it's charged. It's the prosecutor, not the victim. They take the victims into account, but they make the choice. So the victim might not be willing. The other thing to look at is look at the parties to the case. It's the defendant and the state. It's like the state, not the person who was injured, not the person who was, victimized in some way. So it's the state's decision. So consent and condemnation, not defense. Stress disorders can have an effect because they affect one's mental faculties. PTSD is a good example, whether you're talking about, soldiers who've experienced some of the worst things humanity has, or whether you're talking about domestic violence, which can also be a different type of worst things humanity has. It's like, if you've got an established history of violent and potentially deadly domestic abuse, and finally the person who was victimized, stopped their attacker and killed them, it's like, yeah, you got a good defense there too. The jury's not going to convict you if you can establish that. And here's where I break out into the Oklahoma statutes. And with that, a short video. Sorry for taking so long to get these out. It was a hectic week. So I think I said that the first part of the first video. There was no quiet place to do this. I'm actually surprised it's this quiet right now. And it won't take me as long to get videos up for this week. I'll have a few videos to make because it takes me generally about 3 to 4 weeks to go through all this stuff in class for next section, because we're talking about homicide and then other crimes against persons. Homicide itself usually takes me anywhere from, if I'm going real fast, a week and a half to maybe 2 weeks in and of itself. And then the other serious crimes against persons, it's like that's usually another couple weeks in and of itself. So I'll probably make a few different videos on that. Maybe one long one, just depending on how long I can have to kind of sit in front of a computer in a quiet place. With that, the discussion for next weekend will have a couple of different options on it too. So, because it's going to be sensitive topics, so you can pick whatever topic you want to have a decision, have a standpoint on those topics or not. It's entirely up to you. But whenever everybody's kind of wrapped up with their discussions, I'll get in there and start posting some stuff too. And I'll have grades for the last discussion. Well, I should say first discussion and this upcoming one, which is due tomorrow, up soon. It won't take me as long to keep up with grading. This is one of the few times where I've had a busy week over the summer. I'm not looking to have many weeks like this last one over the summer. Visiting family's nice in moderation. But with that, if you guys have any questions or need anything, just let me know. I'm only an email away. Whenever I get these videos uploaded, I will send out an announcement to the class. And if you need any more time for the quizzes, the quiz from this week, which is due tomorrow, just let me know, or any additional attempts. I think I pretty much had everything that was in the quizzes either identified in the PowerPoint or the outlines that or the statutes themselves that everyone should have had a fairly easy go with the quizzes. And if not, though, just let me know and we can look about how to address that. So hope you all have a great day, and I will see you soon. So you all take care and